Good evening. My name is Joe Sam Robinson, and it's my pleasure tonight to have with us Dr. Buck Melton. Welcome, Buck.
Always glad to be here.
We've had lots of useful interchanges, and I think it might be appropriate to discuss the legal system, as you are a representative of that particular profession. Is that correct? And
sort of, kind of.
Sort of. Well, besides being a historian, you certainly have got a foot in the law world, as did your father. So you have
to a much greater degree than I.
I see. Well, yeah. Fundamental. The idea is that the American legal system is searching for fairness, righteousness. It wants truth. It wants a society where people understand their limits of what they can do to another person. There's mutual respect. American values are protected. So the legal system is really the keystone part of our society. It's huge. It's a big deal. And so it has many, many good things that it does and attempts to do. And one of the things that might be worth a discussion is comparing our system with the system of other countries, particularly I would say in Western Europe or in the countries that were influenced by Napoleon, and the ideas where many issues that would go to a jury in the U.S. go to a panel of judges in other countries. And maybe each system has its good points and its bad points. It would be easy enough to point out some of the problems of the American jury system, in my opinion. I'm not sure how well I can do for criticizing the European story with judges. Do you want to have at it on this? What do you think is wrong with the European system?
Well,
I'm going to make some comments.
Well, I can start generally that you say Napoleon, and the Napoleonic Code Napoleon, the civil law system, he obviously had a huge impact, but he was essentially refining a system that went back hundreds and hundreds of years before him, so there's a reason why it's called Roman law or code law. And it's essentially top-down law. There are a couple of many differences, but two of the biggest differences between the European and the Anglo-American system is that the civil law system actually downplays the importance of court proceedings. That in Europe, if you and I go to court and we have a lawsuit and there's a decision, that decision really mainly just concerns you and me. So later litigants who find themselves in a similar position, what happened between you and I doesn't really matter. In the Anglo-American system, the judicial decision in our case, if it refines our understanding of the legal rules and legal principles, then becomes binding on later plaintiffs and defendants in similar circumstances. And this is what is known the common law. So the judges actually do play a role in making the law, or as sometimes it has been said in certain phases in our history, discovering these legal principles. It's not all left up to the legislature. Another one of the big differences is that whereas in the Anglo-American system we have what is an adversarial system. I hire a lawyer to plead my case, you hire a lawyer to plead your case, with the idea being that nobody on earth has a greater interest in discovering what will help my case than I do. And same for you. So the judge essentially serves as the referee between you and I on the scrimmage line who are trying to move the ball back and forth and each one of us to score the touchdown. And the judge is there just to make sure we play by the rules. He throws the flags and makes the call. In the civil law system, they don't use the adversarial system, they use the inquisitorial system, which initially sounds kind of sinister. Everyone's thinking the Spanish Inquisition, but it's not necessarily sinister. It simply means that the judge, as the representative of the state, has as big or a bigger interest in discovering the truth as the parties do. So the judge can play a much more active role in questioning the parties, summoning witnesses, examining the evidence. And so he's much more proactive, if you will.
And well, I'll make a few comments and then sail the ship to the States. But it would appear to me that one of the things that you mentioned, well, goes back for centuries. Seemingly, one of the things about the evolution of society is property in past centuries really was a very central desire of the state and the judicial system to protect property. Really, in many ways, if you want to put on the other side of the street, human rights, whatever that is, the property was just pretty much paramount to the whole deal. And so in the European arrangements, at least for a long while, if you were a little guy and you wanted to do something, a lot of things happened. Like point number one is starting the trial, and maybe this is not true on the continent, but certainly is, I think, in the United Kingdom, is if you want to sue someone, you have to pay the lawyer out of your pocket. The lawyer cannot take half the winnings. So if you're a poor person, it'd be very difficult to get in there. Mm-hmm. Other thing is the trials often go a long time. And I believe the people that are the judges are put in there sort of as super civil servants. They're sort of, and they try and be as immune to corruption as they can be. And also I think they're well compensated, or they're sort of a very privileged position. And they at least try and present the idea of tremendous neutrality. And so the decision that appears, this would be the hope, is to be some very smart, neutral people that would not be swayed by rhetoric or issues that are emotional. They would just cut to the facts. Here, just sort of a Joe Friday kind of thing. Here are the facts, 1, 2, 3, and that would be the black box from which comes the decision. And presumably, I don't think there's much, at least on the continent, much desire to have the American arrangements there. And the safeguards, if you want to say that, in the American system, whatever, are not in evidence as much on the continent. And indeed, many people that would say, boy, how do you guys handle the American system, as witnessed by some of these extraordinary verdicts that are being handed down in the U.S., particularly against property, which you could say maybe in Europe would be more protected. But the adversarial system is fine. But the question to be asked is the jury pool. So in the European arrangement, these allegedly neutral civil servants that are just interested in facts are going to come up with a decision, and in regards to science, whatever you could imagine, that I think they would, not always, but they would comport with what a rather neutral view of reality would be, and would be unswayed by emotion. And so I think what's going on in the U.S. is firstly where the issue is on juries. And you could also say to some degree on judges. So the judges in many places are elected, and the bar plays a big role in contribution to the judges. Whereas in Europe, the judges are very neutral and not involved with any of these arrangements. There's state employees, they're put there. There's the people that come before them they have no relationship with. But in the U.S., the judges are often, particularly where they're elected, their money comes into their hands from different sources, and indeed, many judges have a political background, and indeed some judges are there for a while, and then they go over to become attorneys again, and having been a judge, can make a lot of money So we have that sort of thing going on with the judges and the jury pools. As I understand this, the net is cast very wide for this. I think in Georgia, formally, the jury pools were very restricted, and there are lots of things that happened. I think particularly in federal court in Georgia, as I understand it, there used to be a way where the only people that could get on a federal jury were the system sought out people that had the prerequisite intelligence and moral standing to go into the jury pool, and those would be the only people that presumably would be in the jury. And so if you were an aggrieved person, that you had your own, these people, if you were sort of not in the middle of the establishment, you're a non-establishment person, and these would be establishment people on the jury. That would be bad. And additionally, the way the jury was constructed in the past, there were lots of limitations for many ways, limited certainly by race, ethnicity that was going on, and gender. So there were very restricted jury pools for a long while, and I think, for instance, property requirements. You couldn't easily get on a jury if you couldn't vote, and they were at least a long time ago. And the jury was restrained, and they had a very, very conservative bent. And if you were a person that was not in the establishment, or you were an Afro-American or whatever the story is, you would not get a fair shake. And so to correct that, I think the situation has been really, really opened a lot. And for instance, in Georgia, I believe the case is that if it used to be you had to vote, you'd be registered to vote to be on a jury pool. Now it's been expanded, as I understand it. So if you have a car registration, you could go in. So there's a very, very wide net that's put there to put people in the jury, in the jury box. And a question to ask is, the people that are the advocates for each side are really, really skilled at, say this mildly, at sophistry and trying to influence the people that are in the jury box. I mean, they're pretty good at it. And often in these situations, particularly when there's a trial against a property, there's human rights involved against whatever property is. And so a big company has polluted the river, and someone has to, it's be a common story, a big, huge, distant company that doesn't really care about the little person has in some ways polluted something, or they've produced, shall we say, a big recent settlement was talcum powder causing all sorts of cancer. Or you could say the famous thing that's on television a lot is the fact that Camp Lejeune, the water was contaminated, and almost anything that happened to you after this, you could get some money for it. And I believe in the talcum powder thing, Johnson & Johnson is putting $9 billion out there to see if they can take care of it. And billions of dollars are being obtained by people that had some problems with the water at Camp Lejeune. So what I'm sort of getting into is that if you put a system there where the jury can be inflamed, if that's the right word, against a distant property owner that's going to hurt people, and they want this rectified. And so they're going to be, I would say in some ways, misled in regards to causality. So causality is very complicated, and if the I guess the plaintiff's attorney can have some kind of relationship between this might have maybe 1/1,000,000th of the problem could be referable to this particular thing, or 1,000th or whatever, that we're going to make that totally the story about who's going to be compensated.
Well, I've got to stop you, because once again, I could teach a 2-year course on what you said in the last 20 minutes. But
I'll throw you the football.
Well, I'll start by saying you're going in two vastly different directions. You're talking first judge and then jury.
Well, they were part of the same process. is the
Well,
reason I
they're
did it
part of the
that
same
way.
process, but they have two entirely different roles. And so if you start conflating them, you immediately
Well, I
run into
mean, I
trouble.
wanted to go to
Yeah.
the whole. I'm glad I got a response out of you. Good. Go
Well,
forth.
yeah, as I said in our previous program, you are a cynic about the law, but at the same time, you seem to have this naive idea that there is such a thing as absolute truth, which judges were notorious for believing during the 19th century. I'd also say, as you were coming down on all these elected judges who have political agendas, I bet you would have an equally cynical response to federal judges who are appointed rather than elected, and they get on there for life and therefore have no sense of restraint and therefore openly indulge in
Well,
so
good.
you
You're
can't
going
win.
to-
Can't win for
you're
losing.
piling
If you
these,
can't win for losing.
You're
Yeah.
piling on my
Yeah, but
shortcomings, but I'm going to
Yeah.
respond to it. Go ahead.
all right.
Speak
So,
up.
but excuse me. The word BASS. How do you pronounce that?
Bass?
No, it's bass. You're obviously a fisherman. I'm a musician, therefore, which is true? How about UNIONIZED?
What is that? I'll have to write that out.
You as a scientist would say unionized, but I as a labor lawyer would say unionized.
Well, we can get into words. I mean, we can.
Yeah.
I mean, in other words, I totally take it.
Yes.
Their words are extremely imprecise.
So you have this idea,
and
but not just words, quantum theory. When you get into quantum theory with mass being energy and Schrodinger's cat, that we have this idea that there is a truth out there, and that this legal system, both the judges and the juries, are being so manipulated or have such an agenda that they are departing from the truth or are misled from the truth by these evil attorneys who engage in sophistry and lead them to a result that is not reflective of the truth. I've got some serious.
Well, okay.
Certainly there are major biases. There are huge problems both with juries and with the politicization of judges, both elected and unelected. But this blanket statement that the whole system is just it fails miserably at achieving its goal.
I can respond to that a little
yeah.
bit. Firstly, yes, indeed, it's very hard to know truth, mathematics, quantum
Is
theory.
there truth? It's not knowledge. Is there
You
truth?
could say there are
Yeah.
different spheres in the Newtonian world that's out here, and as you get down, the whole story with causality gets quite complicated. But in our level of the ocean, so there are different levels of the ocean. I mean, maybe we're in the Newtonian thing. We can at least, when we bump up against the truth, we can sort of, with some caveats, say, okay, that's fair enough. Now, where I'm attempting to sail the ship is and I picked some examples. Obviously, what are we going to compare this with? The jury outcomes, and I've just been impressed with things, to my knowledge, this is just nuts. I mean, the decision the jury came up with appears to be nuts to me. And as an external observer, maybe I'm missing something, and increasingly so. And I think a lot of it is some kind of complicated arrangement between, in our society, whatever human rights are, and causality and property. And so if a particular jury can be obtained that has a certain amount of predispositions to think a certain way, then the outcome can be often pretty assured. And to balance what's going on, I think the artificial intelligence may be able to come up with some, at least assessing this. And so what I would push for a little bit is assessment of different systems in regards to what's going on, and in our society, the complexities of it are a lot. And so the idea that these juries can right wrongs and do good things, and also the little person, if you want to say it that way, or just a normal common man, can really pull the temple down if the temple is wicked or evil. And there's a great sense that our society can work. All those things are a good thing that's part of the system. Now, my problem with it is that if you say, is there anything better? What kind of errors can happen? And then I think often what occurs is, well, this is it. This is the best possible thing to do. And many people that have an investment in the system don't easily want discussion about it. And I wonder if we can, for instance, you could say, here are the facts. Let's just, on a particular thing, this is what artificial intelligence might say about it. We can get some kind of external, as a study, just to say, these facts are so contrary to the jury's decision, so contrary to whatever is going on, there'd be something to discuss. And famously, we have the OJ trial, what's out there. We have lots of things that are like that, and these enormous suits that are taking place against big companies. And I certainly want the companies to be appropriately checked, but in a way, they're having a destructive nature to them, and the rewards that are being harvested by the plaintiff's bar are absolutely astronomical.
Well,
and so in other words, okay, I got it.
Yeah.
Maybe that's all right. That's good if they've done something appropriate. But how does this system compare with other systems? And that's just my question.
Okay. Well, I'll jump in again here. That first of all, there are countless thousands of trials that take place both at the state and the national level in this country every year. How many of those have you followed, the blow by blow in the data? Very few.
Very few.
How many do you hear the outcomes of? Very few.
Very few.
So keep in mind that you've been going after the courts and the juries and the judges. I'll go after the media, because going all the way back to Hearst and Pulitzer and the Spanish-American War, they love sensational stories. So the outcomes that you tend to hear the most about are the ones that can be the most egregious and do produce the most controversial results. Most of them you don't hear much about because you don't see problems of this sort. But if you attend any day-to-day trial, the rules of evidence tightly control what the attorneys can get to that jury, and so you don't see the sort of thing. And if there is an egregious wrongdoing, yes, there is a check on that. There is in federal courts, it's now known as judgment as a matter of law, or more traditionally in Georgia, JNOV, or directed verdict, in which once the jury has reached its decision, and it's some sort of crazy, outlandish decision, there's a motion that says from the opposing counsel, Your Honor, no reasonable jury could have reached this decision, and so you turn to the judge to correct it. And if there is a legal basis for that correction, the judge will say, yeah, I'm not going with what the jury said there. Now, of course, if the judge also, I'll throw in on top of Heisenberg, I'll throw in Freud. Everybody in that courtroom, including every juror and every judge, has baggage.
Of course.
But will the AI not have baggage as well? I would say that the AI is going to make decisions based on the algorithm that was programmed into it by humans. And if you want to get into apocalyptic fiction, a whole lot of apocalyptic fiction is an AI that decides that the most efficient outcome is the destruction of the human race.
Right.
Yeah. So.
Well, what I'm getting at is just some kind of external way to examine the situation, and so if you just say this is it and this is as good as we can make it, but we're not going to have any checks or balance, and maybe some checks and balances are put in.
But there are,
I would propose some more, and or at least more inquiry into it. And so you mentioned the rules of evidence. Well, that's with the assumption that the jury is paying attention to evidence. That's the assumption that the jury is there, particularly in very, very hugely complicated long trials that go on and on. And what the defense says A, the plaintiffs say B. Their experts are going back and forth. It's just one, boy, what on earth is all that about? There's something going on with, I don't know.
And the system, the system does adapt, though. That in recent years, especially in complex, like patent litigation or stuff, we've now bifurcated the verdict the way that we've been doing in criminal trials for some time. First of all, is there a liability here? Okay, now that there's a liability, let's introduce the more complicated evidence to try to figure out how much liability there is. So once again, is that a perfect result? No, but I think that is much easier on the jurors than what we had prior to that. So the system does evolve, it does adapt.
I mean, and the question I would ask too, as you said, there are thousands of trials out there. I mean, do we have some way where all these things are being summated? So in other words, what is the, let's pick Georgia, let's summate what's going on in Georgia in regards to what happened. My understanding is in criminal, there are relatively few criminal trials. People plead. So I don't know, some huge number of things happen. When there is a dispute between, I don't know, somebody ran over my cat or somebody, I don't know, it's a relatively small thing that happened. There are no cat lovers out there. My wife's a cat lover. Sorry.
There's a horrendous case. There's a horrendous case going on right now out in California regarding a little girl's goat, and you want to talk about a sensational case.
What I'm saying is some kind of summation. Let's see what this is what the system costs. This was what it does. These could be some outrider things that are happening. And you've mentioned ideas about trying to reform it or at least examine it so it's a more perfect issue. It's just what I see, and you could say, well, maybe I've been misled by the media putting all these stories out. At least the things that I observe, I say at my distance, well, okay, maybe there's this, maybe I don't have all the facts, but it does seem that the verdict here is pretty extraordinary. And we talked briefly about the situation with President Trump or political ideas, and at least people have said if you're a political figure and you go into a venue where 90% of the people in that venue are on the other side, and you're going to have presumably a jury that'll have 90% of the people on the other side.
Then I'd move for a change of venue, which the system provides for.
Right, but it might not be granted. And then where would you go? I mean, so presumably in that case, well, I'm going to go to a pro.
Well, I'd stop and ask, why wasn't it granted? Was there a sound legal principle for not granting it? So there are checks on top of checks on top of checks. Can they all fail? Yes. Have innocent people been sent to the electric chair, and often for highly prejudicial reasons? Yes, indeed.
Well, I accept the fact that it's not an easy thing to do. I'll accept that. And but my comment is, certainly the system has evolved. I mean, I sort of tried to make that case. And I was trying to make the case, the complicated relationship between human rights and, you could say, property rights. Maybe they're part of it, but pretty much the law was on the side of property. That's a big thing to say. And then it's changing a lot, and maybe appropriately. And the change that's going through that. You could say that whatever the court system is, a lot of it is beneath the surface to know what's going on, and I push for some re-examination of the system. And you defend the system well. I think these lurid cases continue to appear and disturb me. But I guess that's the way it is.
Well, if I have a time for a closing statement, one of my law professors when I was a law student, who was a very illustrious legal figure in the state of North Carolina, introduced me to a very basic formula: L plus X equals J, where law is L and J is justice and X is the unknown. We are constantly in the Western world seeking for that variable that will make the law invariably just. And we have yet to find it, but we continue to seek it.
Well, just so with our species. Well, thank you. Thanks. It's good to have you here. Thanks. A nice job. Thank you.
This program is brought to you by the Georgia Neurosurgical Institute. For over 50 years, rendering neurosurgical care to patients of all social conditions, treating complicated problems involving the brain, spine, spinal cord, and peripheral nerves, endeavoring to encourage quality care, medical research, innovation, and education on a local, national, and international basis.